Great. I think we can go ahead and get started. Welcome to our American Bar Association Center on Children and the Law webinar on the recent publication that we released in December of last year, which provides a guide for the legal community on the Family First Prevention Services Act. And we're going to walk through a couple of different provisions of the Act today, and also use this time to orient you to how to use this guide as a tool in your daily practice in the child welfare legal field. Thank you so much for joining us. Hold on just a second. There we go. As a little housekeeping, we do welcome questions and answers, and we'll try to provide the answers, questions throughout the webinar. So please feel free to put those, rather than in the chat, put them in the Q&A section. We have allotted time toward the end of the webinar to try to address those rather than trying to do them as we go. Also, for those of you who want to adjust the settings so that you can see as we share our screen with the PowerPoint and also the guide, you can use the fit to window function and also adjust the size of the video if you're watching the video portion of myself and Christine as presenters as well. So feel free to adjust as needed. I thought I would start with a little bit of a background just to orient. I know there's a lot of participants today who aren't as directly engaged in some of our day-to-day work at the ABA Center on Children and the Law. And so we wanted to ground some of the conversation today in giving you an overview of who we are and what our role is and why we prepared this guide and want to share some of the information with you all today. So the American Bar Association Center on Children and the Law is part of the larger ABA, which is a membership organization for legal professionals. And within the ABA, our center has the mission of promoting access to justice for children and families. We're a staff of about 16. The majority of our staff are attorneys who come from direct practice in the child welfare space, having represented agencies, children, and parents in different jurisdictions across the country. And then we also have a commission that we work with that is a body of ABA members who are appointed through the association to advise on national policy related to child and youth topics. Most of our work at the center, and this guide is an example, is funded through external grant work. We do a lot of collaborative work, both at the national level, but also very closely in coordination with states and local county governments in the child welfare space. Almost everything that we do is related to either legal representation or looking at how child welfare intersects with legal systems that affect children, parents, and families. We do encourage you to visit our website to learn more about some of the other work that we do, and certainly to follow on social media if you're interested in materials like the guide as they come out. We always post things publicly as well. So enough about us. Today we wanted to make sure that we're grounding the conversation in a participant poll as well. So if you can fill out your role, and in some instances we recognize there may be some attorneys on the call today who represent both children and parents in different cases, et cetera. So please choose the one that you think is most applicable for you, and that will help us have a good sense of who's on the call. Great. And Claire, I think you have the controls. Perfect. Thank you. So hopefully you can all see the poll results. It looks like we have a great mix of agency, children's attorney and GAL, parent attorney, and then agency administrator, court administrator, judge, and caseworker and other, which hopefully people can provide some additional details on the back end. Thank you. It's really helpful to have a sense of who all is here, and especially to see the diverse mix. Keep us. So today's webinar really has 3 component parts. I'm going to be delivering the first and part of the second, and then Christina will walk us through the sort of second half of part 2 and the third component. The first component is really just to use this hour and this opportunity to orient you to what's in this new publication that we released at the end of last year, and how can you use it in your practice and judicial decision making for judges on the call, and then also obviously for other members of the legal community, ways that you can engage and use it for both implementation and in your direct work as well. The second portion of the webinar will be walking through a couple of examples. We've pulled a couple of provisions of the Family First Act that we have included as separate sections in the guide, and we're going to give examples of how to use those provisions in practice. And then the third component, where Christina will take the lead, is to encourage follow-up. We're here live right now, but we also are very easy to find, and we look forward to engaging with many of you down the road. So before I go into some of the orientation on how to use this guide, we find it really helpful to go back to the groundwork of what the purpose was of this legislation, which came together through a bunch of different bipartisan efforts in the House and the Senate, and really aligns with a lot of overarching child welfare goals. So looking at this act kind of with that in mind, and keeping this statement as expressed in the legislative intent of the House Committee on Ways and Means report when the legislation was first being put together, I think is a good orientation for kind of how we talk about the act, which is that it isn't in isolation from anything else in child welfare. And that's really important grounding, because so many of the overarching goals are things that go well beyond the sort of 4 corners of what the language of the legislation is. And we realize in today's call that there are lots of participants who come from jurisdictions where they're in different stages of implementation, and there's lots of different provisions that require sort of a commitment to implement on a state level. There's other provisions that we'll talk about today that aren't those same in that same category. And so really looking at how to use this legislation and how to use this guide as a tool for achieving some of these overarching goals of the act, and not just the sort of the specific terms and language within the act. So I am going to take a minute to just read this out loud, because I think it's that important, if I don't miss the slide. But the House Ways and Means Committee report really recognizes that the public and human cost of removing abused and neglected children from their families and caring for them in foster families, group homes, or institutions is substantial. And federal expenditures in foster care totaled more than $8 billion at the time when these provisions were first being put together. The majority of children, this is part of those findings, is that the majority of children who enter foster care end up either reunifying with their parents or principal caretakers. So at the time that was 51%, or going to live with a relative or guardian. At the time that was 15%. And those numbers have changed a little bit from year to year, but are still in a similar range. Given the intense emotional trauma associated with entering foster care, as well as the cost to both state and federal governments, there's great interest in identifying ways to promote family stability, reduce foster care entries and lengths of stay, and facilitate reunification and kinship placements. So again, hoping that we can kind of use that as the grounding framework for the discussion that we'll have about the different provisions. In a nutshell, the Family First Act goals are to reduce foster care entries through increased use of prevention services, to prioritize placement in a foster family home, preferably with kin, to limit the use of group care settings based on specific needs, and to support transitions out of foster care. So now I'm going to transition not to talking about the act itself, but really to talking about the legal guide and how we hope that you all will use it in your practice. So the background on the legal guide is that in 2019, the ABA surveyed about 500 legal professionals in the child welfare space And we asked what people were looking for to better understand and implement the Family First Prevention Services Act. And the sort of overwhelming response was that people wanted not just an overview of the act, not just kind of a 101 of what's in it, but clear information about how it affects legal practice. And so that's what we sought to do. The purpose of the legal guide sort of falls into three main categories. The first is understanding how this legislation changes or in some ways complements existing federal child welfare law, to identify opportunities to use this legislation to enhance legal advocacy and judicial decision-making, and to support implementation in a way that isn't just about sort of meeting the requirements of the act, but is about going back to those overarching goals and making sure that in our responsibilities as legal advocates, we are ensuring that the implementation of this legislation is always sort of anchored in an effort to best serve children and families directly. So the way that we've organized the Act is a little bit different than how, the way that we've organized the guide is a little bit different than how the Act itself is organized in the legislation. What we thought would be most valuable is to do it by chronology. So we've followed the family's potential involvement with the child welfare system as the sort of orientation of how we've structured this guide. So part one is that we look at the provisions of the Act that really arise before a petition has been filed. So that's primarily the prevention services components. In part two, that's really looking at after a petition has been filed and looking primarily at issues of placement for a child or youth who is in foster care. So the provisions there are the family-based substance use treatment setting for a child to be co-placed with a parent who's receiving substance use treatment. And secondly, foster family home setting and kinship services as a priority area for placements in a family home, and then group settings. And Christina will talk more about that component a little bit later. The third part, the third section of the guide is during a child or youth's transition from foster care. So that's reunification services, provisions of the Act, and older youth supports. And then, as those of you who are very familiar with the Act know, there's a few assorted sections that don't fall easily into that sort of chronology. So we have a separate section at the end. So how did we organize within each of those parts? What we did is we broke down the individual provisions that we wanted to address that had the most relevance for attorneys and for judges and other legal professionals. And so what we did with each of those provisions is try to create sort of a consistent sequence of how we were describing those provisions. So first we provide a basic overview of the provision, what it does, why it was included, and how it works. Then we explain more specifically, going back to that 84%, that sort of request of how can legal professionals use this as a tool. We explain how the legal community can use this provision to inform legal advocacy and judicial decision-making. And what we've done in most of the provision sections, and I'll walk through one of these in just a minute, but is to break it down by if you're a children's attorney, if you're a parent attorney, if you're a child welfare agency attorney, if you're a judge, what are the ways that you can use this provision in practice and decision making? And then the other category is how can the legal community support implementation? So sort of taking it out of the immediate case environment and looking at the broader implementation process within your community, whether that's within a county jurisdiction or within a state. Then we have a section in each where we go through each provision that looks at what research can you cite. This is a legal field, and so we really want to emphasize the importance both for the judicial decision maker and also for the legal advocates, for the attorneys in the case, to make sure that you have access to what are the sources of research, whether it's medical research or legal research that can help bolster your argument when you're trying to use several of these provisions. And then finally, and this circles back with one of the things that we heard a lot too, in terms of high interest and high need, but we've really tried to emphasize in each provision also how it connects with other child welfare laws. And we have a whole appendix at the end of the guide that outlines the way that these provisions connect with existing child welfare law at the federal level, which often, of course, has correlation with state. Okay, so I'm going to get started. As I mentioned, for this second part of the webinar, I'm going to walk through one of the provisions as an example of how to use the guide and how to use the provision in practice. And then Christine is going to walk through another. I'm going to close my close this screen, so bear with me for just a moment while I excuse me, close this screen and open up the guide itself to walk through that provision, the provision on co-placement with a parent. Okay, so this, as those of you who've already taken a look at the guide, and I hope that's a lot of you, this is the front page, and I'm going to flip us to page 9. So this is part 2. As I described, this is the second section in the chronology, where we're really looking at what are the provisions of Family First that have the most bearing and the most relevance after a petition has been filed and a child or youth is in foster care. And the first one of those that we look at very carefully is a provision that addresses family-based substance use treatment. So this is the section of the law that provides, in terms of the sort of like, what does this provision do? This is the section of the law that provides for the opportunity to use maintenance payments, so the cost of supporting a child while in foster care, to cover some of the cost of a child who is in a setting where the parent is receiving substance use treatment, and so allows the child to not be removed from the parent's care while the parent is undergoing treatment. And the sort of why was this provision included piece, I think, is a really important grounding in this one in particular, which is a recognition both in research and in case outcomes that parents and children often do much better when they have not been separated. That doesn't mean that care is not needed. It doesn't mean that there are not treatments that are necessary in order to get to a safe space and a safe final permanency outcome. But it does recognize that, especially with very young children and infants who are separated from caregivers, that in and of itself, even though they cannot articulate it, can be an extremely traumatic experience in their life trajectory, as well as in their parents' life trajectory, and is something where, when available, treatment that can provide support to the parent to continue to be with a child can be a very important way to mitigate the risks of that trauma. And so I'm going to scroll down a little bit. And this, again, is where, if you're having any trouble, you can sort of play with your own view options to see if you can fit to the screen, or feel free to make me very small and the video, and you should be able to see it a little bit better. So what the provision was included in part also because at the time when Family First legislation was first being discussed in Congress, there was a real recognition that there had been a substantial increase between 2012 and 2016, a very substantial, almost an 18% increase in parental substance use being the primary reason for foster care entry. And also in 2017, I think this statistic really underscores the importance of having this kind of a treatment option. But in 2017, the percent of children entering foster care who were under 1 year of age was 19, and half of that 19%, half of those cases involved parental substance use. So again, the sort of underlying purpose of trying to figure out how to change certain federal provisions was really geared at trying to meet needs that had always been there, but expanding needs, especially related to young children who were entering foster care because of parental substance use. The other important piece, as in terms of background, is that traditionally parents have had the ability, or a greater ability, I should say, to have public support while they're in treatment, but children have not been able to be supported. The costs of a child being in that treatment with a parent are not covered through public funds. And so that was the concept behind this significant change in the federal law, is to allow for that child to remain with the parent and to have support through public funds to do so. The A couple of the pieces of the how it works that I do want to, I'm not going to walk through all of these, but I do want to highlight is that it is necessary for the child to have been removed, to have been by law placed in foster care. So we're not talking about sort of a prevention service here. We're talking about a situation where a child is officially considered to be in placement in foster care, even though they are remaining with a parent while the parent is receiving treatment and support. So then this is the section that we talked about, and I will, Christina showed me in advance that I can circle things, which will make my kids really entertained because they like the idea of being able to circle things in books. Although I did a very poor job here, so I apologize for that. But this is the section where we really were trying to meet that request of the 84%, saying that it's not enough to just understand kind of the 101 of what Family First is. People really wanted to see more information about how to use these provisions and how to use both the language of the law and the goals in practice. And so here we've broken down, for example, Child Welfare Agency Counsel, that if the case involves, let me get rid of that. If we, oh no, and I've unfortunately, Christina, I've bungled the whole, I've bungled the use of the tool. But here we have Child Welfare Agency Counsel who have an opportunity to talk with the caseworker about whether placement with a parent during treatment is advised to facilitate a reunification goal and to minimize the trauma of separation. We also have down here that if this placement is not advisable, being prepared to explain in court or to the child's attorney or the parent's attorney why being co-located with a parent who's receiving substance use treatment isn't advisable. Down here, when we look at child's counsel, this is a really important piece because children's counsel often cannot communicate directly with obviously a young child client, but nevertheless need to be able to represent those interests. And so this is where there's a lot of research on the benefits for young children being able to continue in their parents' care and in that bonding scenario with a parent or caregiver. And so, so looking at this from that lens of child's counsel advocating on behalf of the client to have their interests served by being co-located with a parent, and really looking at the benefits that may entail for the child. Also looking at whether there's a heightened medical need that would or would not be met at the residential treatment facility for a child, especially who's been born substance exposed. For parents' counsel, it's really important when talking about this provision, not only to understand where potential facilities exist, because that may complicate a parent's decision about whether it's the right choice, but also to understand and advise the client that because this placement option requires that a child be in care, there are elements of this decision that could implicate the timeline of a case in foster care. So if the child wouldn't otherwise be in foster care and there are alternative options, making sure that the client understands that component as well. Here I have for the judicial decision maker, and I'm so sorry because I see that this silly thing is still on my screen. I hope it's not on your all's, but I do apologize if the red band is still on your screens. I'll figure out how to address that in just a moment. For the judicial decision maker, one of the things that we had up here is really asking about the potential implications of the 15-month timeline and examining in coordination with the agency whether this kind of placement could be considered compelling reasons to not file, for example, a TPR petition if the child has been in care for 15 months, but has been placed with a parent for the substantial portion of that time while the parent's receiving treatment. The other segment that we had here was reviewing and citing medical research and case law to support the importance of parent and infant bonding, especially during these early stages of development. So I'm going to scroll down a little bit here. This is the how can the legal community support implementation, and this is probably the most important bullet, which is looking at this directory that we have a link to in the guide that provides information about where these co-placement options do exist. And if you don't have them in your community, looking to learn more about what it might take to try and encourage something, an existing facility potentially that's providing substance use treatment that might be able to provide this kind of care with children as well. And then the other thing that I will mention in terms of the way that we've oriented the guide is we did include in each provision research to cite. So this is one of my favorite components of it, but what we're trying to do here is make the advocacy component a little bit easier in practice. So if you are working on a case either as agency counsel or parents counsel or children's counsel, and you really want to be making a compelling case for co-placement, these are some of the resources out there that provide medical analysis of the benefits for children of remaining in that bonding relationship with a caregiver who's receiving treatment, but also benefits for the parent and the caregiver, which is especially important for reunification goals. And then a couple of these down here I thought were interesting and important to cite too. We have the National Academies of Science that talks about the importance of bonding and the trauma of separation. And also for judicial decision makers who are already very familiar with, but the National Council of Juvenile and Family Court Judges, the Enhanced Resource Guidelines, talk about the importance of that early relationship bonding and efforts to prevent disruption. The final thing I wanted to show when walking through how to use this provision comes on page 40, which is the appendix I mentioned about how these different provisions of the Family First Act connect with other existing provisions of law. So in this instance, we have co-placement with a parent is the provision that we were just looking at, and how that connects with, for example, in that third segment, 5A of 42 USC 675, which requires that a child be placed in the least restrictive, most family-like setting available. And so looking at co-placement with a parent as meeting that federal requirement and federal goal, in addition to how it fits in with the larger goals of the child welfare field and the larger goals of Family First. So I will stop there and pass it to you, Christina.
Thanks, Prudence. I see a number of questions while I'm sharing my screen have come in, and thank you. We will try to attend to them while I'm sharing the next section, but also we do have a section toward the end of this presentation to devote to Q&A. So we will try to address them there if we're not able to earlier. What you should see now is another section of the guide. This is the group setting section, and it is also in part 2, which Prudence highlighted about chronologically in a case after a petition has been filed and the child has been removed from the parents and is entered foster care. This part C group setting covers the 4 areas the Family First Act describes that are placement settings, that are congregate settings that states can access federal dollars for to cover the placement costs. I will touch on very briefly the first 3 and then go a little more in depth and show you how our guide organizes information around the 4th, a newly defined group setting. And these, as Prudence was saying, each section of the provision really supports primary principles and goals of the Family First Act. Here, there's a prioritization that appears elsewhere in the Act of family-based settings for youth who are in foster care, children and youth. The goal is really reducing the inappropriate use of group settings or congregate care settings, and these elements and these provisions almost most directly address that goal. They also want to shape group settings to make sure that they are safe and that they're used only when absolutely necessary and when the treatment or the setting and service needs that the child needs are not available in a family-based home and family-based setting. So as in the other sections of the guide, we go through and provide a summary overview of what the Family First Act says about the different settings. So in this case, Family First does support federal funding for group settings that specialize in prenatal, postpartum, and parenting supports for youth, supervised independent living setting for youth 18 and over, a high quality residential care setting for youth who are either victims of sex trafficking or who are at risk of becoming victims of sex trafficking. And all those 3 settings were things that were available to courts and to agencies rather in states prior to Family First. But this new placement is known as the Qualified Residential Treatment Program. It's a residential treatment setting for youth with serious emotional or behavioral disorders or disturbances. And I'm going to skip ahead to that section in the Act, though you'll see it follows the guide follows the same structure that Prudence highlighted, giving a brief overview of the particular provisions that are relevant to the court and legal community, and then getting into more detail about considerations for individual attorneys, for judicial decision makers, and for others thinking through implementation and effective implementation of the Act. For anyone who knows even a little bit about QRTPs and this higher level of treatment care for youth and foster care, you may know there are a number of details in the Family First Act outlining all elements. I mean, really what a QRTP or this residential treatment setting should look like, how it is staffed, how it is certified, and the whole process for a youth entering that placement and it being recommended by a qualified individual who carries out an assessment that is also described in detail in the Act, making a recommendation for that placement. So you can get a summary here in the guide, which I won't go through right now, but please do look back at these pages for both the steps that would lead to a child's placement in the QRTP or similar residential treatment setting, and then the court approval and monitoring role, because that is something that's carved out in the Family First Act, which we highlight here, and want to make sure courts and attorneys are aware of what role the court can play in making sure that this is the most appropriate placement for this youth and the service needs can't be met in any other way. So as Prudence has noted, after describing these provisions in Family First, then the guide goes into specific considerations for attorneys and judges. So I'm going to hold off on circling anything, lest it travel with me across pages, but I will note and highlight if you need it, so let me know if you can't see. Some particular recommendations, for example, for a child welfare agency counsel. So for someone who's representing the agency or sort of bringing the petition and continuing with the case in a sort of prosecutorial role, there are obviously certain requirements under Family First that the agency need have met for the QRTP placement to sort of pass muster, and for the court to and others to agree that it's maintaining that placement is appropriate and continuation in that particular placement is appropriate. But we also want people not to lose sight of the agency attorney role and other responsibilities. So while you have certain requirements that are based here that we have drawn based on the Act itself, don't forget that the agency attorney should also be explaining how this particular placement can support the child's overall permanency goal and other treatment needs the child may have. And other needs the child might have, not just treatment needs. So for example, we've included down below, how is this placement meeting the requirement to ensure a child lives in the least restrictive setting possible, which is a requirement under federal law and most state laws. And similarly, how can a child's normalcy goals, the prudent parent standard be met in this group setting? Those are things the agency attorney also should be highlighting and considering regarding what evidence to present to the court and to other attorneys regarding this child who has been placed, or at least recommendation has been made to place the child in a QRTP. Similarly, there's a great deal that child's counsel can do when thinking through the appropriateness of the child's placement and advocacy based on what the child wants. Depending on the child's interests and level of comfort and needs, there's a lot of room for advocacy by the child's attorney. Starting with has the child had a voice in this placement and in this, especially if it's a transition from a family-based or another type of setting, the qualified individual who is making the assessment about whether a QRTP placement is appropriate and meets the child's needs is supposed to incorporate the recommendations and the thoughts of a family and permanency team or the treatment team that is made up of the child and persons important to the child and to the planning and sort of permanency plan for the youth in particular, including if the child is 14 and older, up to 2 people that have the child has chosen to be a member of this team. So that's just an important element and that's in our little review and summary of the plan for QRTP assessment, but it's something important for a child attorney to remember that, as always, it's critical to have youth voice whenever possible when you're talking about where a child is staying, what services they're accessing, and all those other elements. And if the child doesn't want to meet a QRTP, do some active investigation and advocacy about what else is available, what alternatives may be available to meet the needs identified for this child. There are a number of other recommendations here that I will leave you all to look through at your own pace and on your own time. But don't forget also parents' attorneys can advocate regarding a QRTP placement or residential treatment placement, depending, of course, on what the parent wants and thinks is best for the child. I would say a couple key elements are making sure the parent is able to continue to visit and spend time with the child, of course, in consultation with the child and the treatment providers. But just because a child is moved to a residential treatment setting doesn't mean no visits are available, no phone contact is available. It shouldn't be a default to cutting off contact with the parent. Additionally, if the child's goal, particularly if the child's goal is reunification, the parent can be involved in the decisions that the treatment team at the placement setting is making. And QRTPs, the facilities themselves or the settings themselves are required to provide follow-up care and services to a youth who is discharged from the QRTP for at least 6 months afterwards. So make sure that the parent is part of that planning and can access services that might help the parent engage with the child if the child is returned immediately home, certainly, but even if the child is going back to a foster family setting, whether it can or not, make sure to try to include the parents in accessing some of those services and support so they know what support the child may need going forward after he or she or they have been in the QRTP setting. And then, of course, the judicial decision maker has some considerations to make regarding the placement and may need to start by developing new standards to evaluate the assessment that comes in recommending this QRTP placement and how the court is going to monitor cases going forward. If a youth remains in this residential treatment setting, what other evidence do you want to see? And how are you going to evaluate the evidence and in what format and what context? I mean, there's some new areas to really discover as a court administrator, as a judge, to apply to these cases going forward. And then there, of course, we have included some recommendations for joining in effective implementation of these group setting requirements from Family First, which you can see here, and including starting with, do you need any change to state legislation or court rules? A lot of states have been moving toward or have already enacted legislation that will allow the agencies and courts to be complying with the Family First Act when it becomes effective, if it hasn't already in their jurisdiction. But what about court rules? Are things going to need to change regarding QRTP assessment reviews and anything else? So those we recommend every interested person be involved in developing that so that everyone's on the same page and then it's communicated well to the whole group so everyone knows when there's a change, what those changes may be. And I will continue with what Prudence highlighted and showing the relative federal laws, which again are largely in state law as well, that shore up these requirements of Family First Act. I mean, they are not sort of islands of best practices or promising practices coming out of nowhere. The Family First provisions in the group setting category, as in other areas, are really building on principles that folks in the child welfare community have known for a while and that have been required for a while, like a child needs to be placed in the least restrictive, most family-like setting. And the reasonable and prudent parent standard should be applied no matter what setting the child is in. So as you can see there, they follow some of what Prudence had talked about, and then these particular provisions apply in a number of different areas. I think I will now stop sharing this. And I see we have a number of more questions, so I think we can transition to our Q&A period, and I will share our PowerPoint once again. So please bear with me while we put this up, and then Prudence and I will be happy to attempt to answer some of the questions. All right, so here we are.
And Christina, since I see that a couple of them are specific that came in regarding the QRTP review process, I'll give you a second to orient on those questions, and I can try to dive in on a couple of the ones that came in earlier related to the co-placement. So one of the questions related to the co-placement provisions is about the age of the child, and does that the question is, does the age of the child enter into the decision, and at what age does the child, at what age, I think, does it influence the decision about a child being able to reside in a treatment facility with a parent? And the answer is absolutely. The age is very relevant. There are not legal standards around the age that come from the federal law, but there are a lot of specific requirements at the facilities themselves. And then within the jurisdiction that may be making a decision about whether that's the right placement for a child, certainly the age of the child has a lot of bearing on the bonding with the parent, and also relationship to siblings, relationship to other caregivers who the child may already be bonded with if older. So the answer is yes, very much. There's not a firm age within the federal law, but it does matter very much on the implementation side. And then another one, which I think relates to a different question that came in too, but is regarding the legal custody. So if a child is in this co-placement setting with a parent, that does mean that they are in, technically they are in foster care, and they are in the legal custody of the child welfare agency in the jurisdiction. And I think there was another, I forget which other one was related to that. It may be in the answered section. So Christine, you may have taken care of that already. And then two questions from the same individual. The first is, does it matter the length of out-of-home placement before reunification in a treatment program with a parent? And I'm not sure I know exactly what this question is asking, but it doesn't matter that the child's placement in a facility with the parent has to be in the case plan before the child can be in that. And so it is possible that a child would be in a different placement first. But I think as envisioned, the idea is that this would be the first placement when the child enters foster care, and that there wouldn't be sort of like something else before the child's placement with the parent while the parent's receiving treatment. But it is possible that there would be circumstances where a child would be in a different placement beforehand. And then the final is, will this legislation increase the number of mother-baby recovery programs? That's absolutely the goal. And we have seen that a little bit already in the past couple of years, but yes, now the financials of being able to provide support for the child while in this kind of a program is exactly what the goal was.
Thanks, Prudence. I will try to cover some of the QRTP related questions. And I should note before we go on, there's more information in our guide regarding advocacy tools and research to cite in your decision making and in your advocacy that you can go through, and may have some answers to the thornier questions of sort of the background about group placements and judicial decision makings and things like that. Additionally, momentarily, we will show you some resources that you can check out yourself for more information and Q&A about the Family First Act. But to try to answer some of these questions, someone has asked about the qualified individual who is to do an assessment to determine whether placement in a QRTP is appropriate for a child. The Act does say that the qualified individual shouldn't be an employee of the child welfare agency or someone affiliated with a placement setting, but there is the ability of HHS to waive those requirements. And the person posing the question notes that there's some concern about the waiver and how and when it would be appropriate. Do we have any thoughts on this, or does HHS have guidance on how they would apply a waiver standard? That's a great question. I mean, the overall purpose of that section in Family First is to make sure that it doesn't become, that there's some independent thought being given to whether a QRTP is an appropriate placement, and that it's not the agency just checking a box for itself to say, yes, we think this, and we've been through the motions. This is an outside person we've recruited or paid to do this assessment. I actually haven't seen, this would be a great question for people more involved in the agencies, because I haven't seen the language some states are using for this exception. I will point you to the resource that we will, that I think would most directly answer this question. I think that the goal is making sure that it's an independent person who is doing these assessments, and a qualified person, and not just in the terms of the law, but somebody who knows what a serious or emotional disturbance, how it manifests in a child, what treatment is needed, what treatment may be available in other settings, in home, and things like that. So I think that the agencies do need to be careful. I don't know that how much detail HHS has provided about how they're going to make these waiver determinations, but Prudence, if I don't say it when we go to the next slide, remind me to point out where I think the answer to that question may be. Regarding the question about court rules or statutes being drafted about their role in the QRTP process, that's very individual to some states and even local jurisdictions within the states. We have definitely seen a number of states enacting statutes regarding the QRTP process. Some mirror almost exactly the federal act language. Some are taking a little more consideration about what it will look in their court, in particular, and how the process will be, and what the sort of other requirements will be for their own courts, and it varies really across states. I think the National Center for State Courts has a wealth of information on their states on their site about what state legislation has passed. The National Council of State Legislatures. So that's somewhere to look there. But courts don't absolutely have to, but we do recommend that they consider and draft new statutes court rules if needed, so that they can consistently apply a well thought through process to these cases going forward. There is no minimum age to QRTP placement outlined in the Family First Act. There is a requirement for agency director approval if the child remains in the QRTP after 6 months for a child who is under 13, and every year if the child is 13 and over. So there's an added protection and a sort of a double check about whether the continued placement is really needed if a child is under 13, but that's the extent of the age as outlined in the Act. I saw someone ask an ICPC home study question. There is as you can see in our other provisions section of the guide, there is a requirement in the Family First Act regarding electronic processing and setting up of systems and the goal there is facilitating the ICPC process, the Interstate Compact on the Placement of Children process, which sometimes slows down placement across state lines. The Act does not include any provision to overcome the requirement of the ICPC. And it's not, states have some time to use the money that they've been provided to improve the ICPC system. I'll try to answer a couple more questions. For states that are waiting until the fall deadline to implement Family First, the assessment and court approval requirements do not yet apply to children. So those who are already in placements on the day the new funding rules go into effect, it doesn't apply to them then. It will be the children in placements as soon as the process goes into effect, newly in those placements. I hope that answers your question correctly, Amy, or fully. I see a question, no dumb questions, but the question is, where do you get the guide? It is in the chat. I think Claire has put the link in the chat, so you might want to scroll up to the earlier in our talk to find the link, but I will give you shortly another resource, another way of finding it, a reminder of where this is, where the link can be found. I see the question of, does this also require each state to regularly assess the RTC, I assume you mean residential treatment center, and community wraparound services? The Act wants states looking at what prevention services, which we didn't even touch on, are involved, what group settings are offered and what services are there, and whether they really are needed in a group setting versus a family-based setting, what services are available to youth. I mean, it's more than requiring states to look at all of that. It's an opportunity for states to be assessing if we are trying to, in the spirit of the Family First Act, keep children out of care when they don't need to be in care, or keep children out of group settings unless they absolutely need to be in group settings for that level of treatment service. What can we do to, in the spirit of all of that, make sure kids can stay home or can stay in family settings? I mean, that provides them an opportunity to do that. It's something, those are paths that many agencies and broader child welfare communities are going down these days in sort of as they consider what services and treatment options they have available. I think I'm trying to see if we have any other questions we can answer quickly, but I want to go.
I thought one I might tackle, Christina, is the one about addiction as a recurring disorder. And so the question is about, the risk of relapse after treatment has been provided and how the Family First Act accommodates the need for ongoing supportive treatment, including additional inpatient stays. So there isn't a specific provision within the Act that addresses that, but there are aspects of the prevention services provisions that do provide support for treatment that would prevent a child from needing to go into care, like that would provide substance use treatment for parents to prevent that. And that can include situations where the child has already been in foster care and has reunified. The other provision that I would direct you to, and you can learn more about in the guide as well, is the reunification services provisions, which is that there's a longer period of support for reunification services through Title 4B of the Social Security Act to try and facilitate a longer term, more stable reunification period. And so those are two areas of the Act that I think help to address that, though the specific issue is not addressed directly in the co-placement provisions.
Thanks, Prudence. We will try to answer questions if we have remaining time, and also feel free to reach out to me if you have any additional questions, especially after checking these resources. The one place that has gathered as many Family First Act related resources as possible is this Family First website, and I think you will see down below in the ABA Center on Children and the Law resources more information that can link you to familyfirstact.org. It hosts a very broad range, as I said, of resources on the Act, summaries, specific area fact sheets and guidance and sample rules, including HHS federal guidance. The U.S. Department of Health and Human Services has issued a number of forms of written guidance that appear on their site, but also on the Family First website. So I recommend you look there. The Implementing the Family First Prevention Services Act is hosted by the Children's Defense Fund, and the CDF and a number of other national organizations came together to create and continue to update this frequently asked question list that now reaches about 200 pages. So any detailed question you may have could be answered there. Although they're not legal or court community specific, there's a wealth of information there, and it's constantly being updated. Again, our center has a page on our website with this guide that we've been highlighting today, as well as a couple other resources, including questions that a child welfare agency can ask and ways to engage the courts and legal community about effective implementation in local and state jurisdictions.
And I'll just jump in there, Christina, really quickly, because I think that ties in with one of the questions that got a couple of thumbs up about concerns from parent advocates that some of the prevention services and other provisions within Family First open up the opportunity for more high risk of investigation and child protective services involvement with families. And so one of the things that we encourage is using that document that Christina just mentioned, which is a tool for the legal community to engage in those conversations directly with agencies to talk about, what are the ways to ensure that services are being provided in a way that is genuinely voluntary. And that there isn't sort of the downstream effects are not an increase in the number of children and families who are engaged in a way that doesn't have positive outcomes for them. And so we do encourage that document to facilitate some of those tough dialogues between the legal community and agencies, because this has been a really important area of discussion.
Thank you for forcing the pause there, Prudence, because that allowed me to remember the Family First website is the resource I intended for the person who had the question about the qualified individual and the exceptions to that and how HHS is responding to a state's requests for exceptions. Look at that area in the Family First website because they have a great deal of information on all things qualified individual and especially agency related and HHS response to state questions. I'll transition next to the technical assistance that we at the ABA, at the Center on Children and the Law, are providing. We have been facilitating conversations between agencies and the court or legal communities regarding implementation and how Family First requirements or principles might inform some changes going forward, or do they need to, are any changes needed, and how can more subtly certain items be included? So we're happy to continue facilitating conversations with interested jurisdictions and bringing these different stakeholders together to talk about Family First and how it affects actual practice in your jurisdiction. We've done a number of trainings for court and legal audiences targeting describing Family First Act to the legal community, to judges, to court administrators and others who are interested on that perspective. And we're also happy to provide some feedback on whether it's court implementation plans or rule amendments, state plans. We welcome the opportunity to work with interested groups and stakeholders in the field. We've been lucky to work with a few states already on these pressing issues as states have already implemented or gear up towards formal implementation later this year. And we are grateful to them for giving us the opportunity to work together with them and their agency and court legal communities. And we would welcome the opportunity to work with many of you as well. So please just contact me if you have any questions. And Prudence, before I sign off, is there anything else you wanted to add or clear that we should share with the group in terms of resources or otherwise?
No, I want to take this moment to just say a huge thank you, both to the jurisdictions where we have had an opportunity to engage and provide support, because we've learned a lot in the process of doing that. And as Christina alluded to earlier in some of the questions, a lot of implementation varies in different jurisdictions, whether that be at the state level or the county level. And so, we've really enjoyed having the opportunity to be a part of some of those conversations and some of those processes. And also a very large thank you to the Annie E. Casey Foundation that has helped support the development of the guide and some of the other materials that you'll find on our Family First website.
Okay. Thank you all. I'm sorry we weren't able to get to everyone's questions. We can stay on for another couple of minutes trying to respond in writing to whoever we can before 3 o'clock. But thank you very much for being with us. And we hope you learned something about using our guide and advocating on behalf of clients or yourselves, or applying the Act and its important provisions to your clients again, or your communities. And we appreciate you spending time with us. So thank you all.
And I promise I'll learn about that red line in the future.